as these other three. What's interesting about intellectual property to me is that we have had federal laws that protect and govern and regulate intellectual property as long as we've had our country. But when those laws were first written, they never contemplated computers or the technological advances we have today. So over time, you'll see these laws that were written without thinking about the computer age being applied to all these intellectual property issues that come up because of the way that computers have impacted the way that we live. And those laws have had to adapt over time to take to account for the fact that computers and technology do exist. So it's also an area where it's hard for the law to move as fast as technology does, and so it's constantly trying to catch up with reality in this area, and it is, but it's just one that's had to undergo a lot of change over time, I think, just because of the realities. So trademarks are what you would generally associate distinctive marks of a business: Coca-Cola, Google, Nike. Slogans are trademarks. Just do it. America runs on Dunkin'. These are all trademarks. And they are a distinctive word or symbol or sound or phrase, or it can even be a design that identifies the manufacturer as the source of particular goods. And it identifies those products as being made and sold by that manufacturer as opposed to others. We see the Coca-Cola logo on something, we know that's a Coke product, right? We see Delta Airlines logo on a plane, we immediately associate that with Delta. Those are trademarks. Trademarks are protected as a form of intellectual property in a couple of ways. You can't just steal somebody's trademark, right? That's trademark infringement. You just can't just use someone else's trademark as your own. We'll talk about that in a little bit more in depth. But you also can't do things that blur the lines. Like if it's not directly stealing a trademark, but your word mark or your art is close enough to where you're trying to confuse the consumers that your product is like the other one, then that's also protected. That's also illegal, and that protects the original trademark. And that's kind of known as trademark dilution. It would dilute the brand if you are having knockoffs or you're having these trademarks that are similar to it but not the same. So it's protected in many different ways. You can't just outright cop a trademark from somebody. That'd be trademark infringement. You can't just use their trademark. And then you also can't do things that would blur the lines of a trademark or confuse the consumers. That'd be trademark dilution. So in order to have a claim or to have a protected trademark, you have to register your trademark with the U.S. Patent and Trademark Office in Washington, D.C. They have requirements for what it takes to register a trademark. You don't need to worry about the specifics of that. But generally it has to be something that's currently in commerce or is going to be put into the stream of commerce relatively soon. They're renewable, so they don't last forever. You have to take the time to go and renew your trademarks every so often. So to have a claim, to state a claim for trademark dilution or infringement, you have to first of all have a registered protected trademark that's widely known. And then you have to show that the activity of the person who's either diluting your trademark or who's infringing on your trademark, you have to show that there is a likelihood of confusion or a likelihood of your trademark being weakened You can show that your trademark is being tarnished, that, like say I've got a, let's say that my trademark is for a high-end jewelry, and somebody wants to knock off my name and use it for what's something to be the opposite of high-end jewelry? Drug paraphernalia. So I could argue that they're diluting my brand by having a name that's similar to mine, that's blurring the lines. Does this high-end jewelry maker also make drug paraphernalia? That would tarnish the image of mine. That'd be an example of dilution. Intellectual property is protected on the federal level. So the first intellectual property laws that we really had were federal statutes, but states also have their own trademark and intellectual property laws as well. So their intellectual property is usually protected on the federal and the state level. Trying to hit the highlights. In general, a trademark will have more protection the more unique it is. And so there's sort of a hierarchy, if you will, of levels of protection for trademarks. The ones that enjoy the most protection are the ones that are in a category that we call fanciful. Fanciful trademarks are those that the word has no meaning other than with that product itself. Coca-Cola is not a word in the dictionary. It only exists in connection with the drink. That's a fanciful trademark. Exxon is not a word in the dictionary. It only exists in association with that product, the oil and gas company. Google might be in the dictionary now because I think it is a verb, isn't it? It might be recognized as actually a word, but Google is a fanciful trademark because it only is associated with the search engine and the website. Rolex would be another example of that. So these enjoy the most protection of all because the folks who came up with those, they made it up and it's become associated with just that product. And there really is no reason, there's not really a legitimate reason to use the word Rolex, Exxon, Google in other ways. So the fanciful category of trademarks enjoy the most protection. Down from that would be a category of trademarks called arbitrary trademarks. And these still enjoy a good amount of protection, not as much as fanciful, because arbitrary trademarks, the word has a common independent meaning aside from the product, like Delta Airlines. Delta is a word. Delta means a whole bunch of different things besides the plane. We do associate Delta with airlines when you combine it with the airline, when you combine it with the artwork, the logo. But it is an arbitrary trademark in that the word Delta does not in and of itself only mean that airline. Dove soap, Apple computer, Target stores, those are all examples of trademarks that are also in the arbitrary category. And they still, again, enjoy good protection because they've strengthened to the point that we associate that word with that product, usually when combined with the logo. You also have a category of trademarks called suggestive trademarks, and those enjoy protection as well. They hint or suggest at the nature of the product without actually describing it, like Netflix or Airbus, things like that. So again, those, if they've built up a certain amount of fame or being well known and associated with a product, they'll have more protection. On the lower end of the spectrum, the trademarks that receive less protection are obviously those that are more general in nature. Things like descriptive marks are generic. Like we can't trademark the word donut. You can't trademark the word clock. You can't trademark the word coffee. And these are just general terms. So on the one end of the spectrum, you've got regular, ordinary words that aren't associated with a product. On the other end of the spectrum, you've got things like, made up words like Exxon, Google, Rolex, and then you got everything in between. There are some descriptive marks that still enjoy trademark protection, like Sharp. The word Sharp obviously is a very general term, but we do still associate it with the electronics manufacturer when it's combined with the product and when it's combined with the logo. We still would associate that. Holiday Inn. The word holiday in and of itself is extremely general, but you put those two together and we do associate Holiday Inn with the hotel chain. So just the more unique, the more independent, the more meaning that the word has only associated with the product, then in general, the more protection it acquires. That's the point that I want you to get from all of that. When courts look at trademark dilution or trademark infringement, they're looking at the likelihood of confusion in consumers. And then they're also looking at what the effect would be on the reputation of the original product or the original brand. So it's not just whether or not people are likely to be confused. If I make, if there's a high-end jewelry brand and then somebody's making bubble gum with that same brand name or with a name that's close to it, we're not going to confuse the two. I mean, it's unlikely that somebody walking in a convenience store is going to confuse this bubble gum with my very, very high-end jewelry. But I don't want my brand name being tarnished or being associated with a lower-end product. So even though there's no confusion there, it still enjoys protection because we don't want the brand to be tarnished in that way, if that makes sense. So it's not just confusion, but it can also be, if it makes your brand look bad as well. It would also enjoy protection. So that's kind of how trademarks work. There is a little kind of a subset of trademarks called trade dress that you also cannot copy or that you cannot imitate. And trade dress would be like the overall appearance of a product. That's subject to protection, like the packaging of a Coke bottle, the shape of the bottle, the blue box that Tiffany uses for their jewelry, or like the interior design of a restaurant. You can't necessarily trademark a design, but I can't go and open a restaurant and copy your interior design to make it look exactly the same. That would be an infringement on trade dress. So that is another form of intellectual property that's protected as well. Counterfeit goods. So let's talk about that for a second. Counterfeit is a little bit different than trademark infringement because in a counterfeit good, I'm trying to sell something as if it were the original. I'm not trying to confuse you, or I'm not trying to have some sort of complimentary product. If you make a Tiffany bracelet and I'm counterfeiting it, then I'm trying to sell you a Tiffany bracelet that make you think it's the exact same one that Tiffany sells. That's obviously illegal. It's just not trademark infringement or dilution. It's counterfeiting. That makes sense. Counterfeiting is just, that's when you're not even trying to confuse anybody. You're just straight up trying to steal from somebody else. A lot of the time, this gets solved by using licenses. So, because litigation is so expensive, if I'm going to sue somebody for trademark infringement or dilution, I really would. In some instances, I'd really rather just make money off what they're doing, as long as it isn't harming my main business. I'd really rather them just pay me a licensing fee to use my trademark. Like college sports teams do this. The University of Georgia G, they license that so that people who make all these other products but want to put the G on things and sell them can do so. You couldn't. I couldn't make a T-shirt with the Georgia G on it and sell it if I didn't have a license to do that. That'd be copyright. That'd be trademark infringement. Could even be counterfeit. But licensing is how a lot of that works out. So if you've got a license to obviously use somebody else's trademark, then you're good to go. And sometimes that works out for both parties. Patents is the next area that we're going to look at. And patents are, we typically associate those with inventions or ideas. You can protect an idea that you have if it's an original. You have the exclusive right. If you own the patent on something, you have the exclusive right to make it, use it, sell it for a certain period of time. It's 20 years on an invention to sell, and then it's 14 years on a design. And then you have to reapply for those patents, or you have to renew them once they expire, and you can do that. If you don't, then it becomes public domain and anybody can use your idea without having to pay you for it. The U.S. keeps it's a federal thing. It's a national patent database. So we don't have each state having their own patent databases. It's a federal thing. And you have to, I've never done this. I've never really gotten into intellectual property law in terms of practice, but there are applications that you have to fill out for a patent. And then there's an approval process where they review it and all that sort of thing. And I'm sure that people do it without a lawyer, but I would also think that if you had a really, really important idea that you were worried about getting a patent for, you would want to go get a good patent lawyer to help you get protection for it. For something to be patentable, for something to be eligible for a patent, it has to be genuine. It has to be novel, meaning it's new. It's not previously disclosed, previously invented. We can't patent something that already exists. It has to be useful. And then it has to be something that's not obvious in light of current technology. So things that are not patentable are things like the laws of nature. We can't patent lightning. We don't patent gravity. Natural phenomena, abstract ideas are not, you can't, the idea of freedom is not patentable. Algorithms, it says, are not patentable, interestingly enough. You also can't patent, you can't patent facts, like, the multiplication tables. You can't get a patent on those. Those are well-known facts. That's not anything new. So infringement happens much the same way as trademark infringement does. If someone else uses an idea or a process that is not original, that belongs to somebody else because they have a patent on it, then that's a form of infringement, and the original patent owner could sue the person who's using it, and your damages would include things like all the money you've made off of using my idea, right? You may ask for them to stop doing it. You may ask for them to maybe you convert that into a license going forward or something, but you certainly have the ability to stop somebody from unlawfully using your idea or your process, your design that you have a patent on. But you got to have the patent. You got to have that protected first. All right, copyrights are a little bit different in that you don't have to register a copyright. So what is a copyright, first of all? Copyright is this intangible right that's granted to the author or the creator that gives him or her the right to own that expression. So the creation could be art, it could be music, it could be a sound, it could be a choreography, it could be words, certain way you put words together. So writing a song, all these things enjoy copyright protection. And again, unlike a trademark or a patent, you don't have to register a copyright. Once you create something, somebody else can't copy it from you or use it for their own benefit. It's automatically granted once your expression is created. Copyrights last for the life of the author plus another 70 years. So if I write a book today, I publish a book today, I have a copyright on that, will last for the rest of my life and then 70 years after I die. Same goes for a picture I take, a painting that I paint, a song that I come up with. All that is protected under copyright law for my life plus 70 years. Copyrights protect the original work from being reproduced, right? Somebody can't sell copies of my painting without my permission. They can't develop derivative work, so they can't use my painting and then sell off ideas that are immediately derivative from it. That'd be stealing from me as well. They can't distribute my work, obviously, and then they can't publicly display my work without my permission or without compensating me for it. So I've already talked kind of about what is protected expression. It's a little bit of a loose definition because it just depends. To be copyrighted, a work must be fixed in a durable medium from which it can be perceived, reproduced, or communicated. That's pretty broad. Like a mime's routine could enjoy copyright protection, even though there's no outward noise or outward audible part of the creation. So choreography would fall into that category. Things like computer software and coding, things like that are we can easily see how those would enjoy copyright. I mean, those are creations, those are things where someone's put together a unique sequence of codes or instructions that produce a certain result, and those, of course, enjoy copyright protection as well. But literary works, musical works, dramatic works, choreographic works, pictorial, graphic, sculptures, film, audiovisual works, sound recordings. Something interesting on the sound, and you'll see this when you do your research, is that recording artists or in the music industry, people have sued other artists for copyright infringement, saying you took my melody or you took these notes that are arranged in a certain way. Now, if I wrote a 3-minute song and somebody else released a 3-minute song with my exact same musical structure, and we could listen to it side by side for 3 minutes and they're identical, that's pretty easy to see that that's copyright infringement, that they copied my work. If I write a minute long series of notes for a trumpet. That's easier to see maybe if somebody has copied that, if there may be a couple notes different. But where it gets fuzzy and where you see a lot of the litigation is if somebody is alleging copyright infringement for just a sequence of notes that is very short, like 5 or 6 notes in sequence. And so you might think, well, how can one person obtain copyright protection over a sequence of 6 notes? I mean, it just depends on how distinctive it is and how much we associate it with that song. I mean, I can think of, I can't off the top of my head, but I know that there are a sequence of 6 notes that if I played it for you right now, everybody in this room would know that's X song. That is X. So we associate those 6 notes played in that cadence, in that exact way as that part of that song. For example, like think about the the Law and Order where they go ching, you know. I mean, that's by itself not a distinctive noise, but we've now associated that with the Law and Order franchise, so that if you play that exact little sequence of notes in the same way, in the same tone, that you would associate that with Law and Order. So same thing goes for sequences of notes. It just depends on how distinctive it is, how well known it is, how associated it is with one person's work. The more distinctive, the more unique, the more we associate it with that person's work, the more protection that it would enjoy under the law. I think that would make sense to you. You can't copyright things like facts, things that aren't original. You can't copyright page numbers. You can't copyright a math equation. You know, you can't copyright, like I said, facts. All those things are not original. Those are not things that the author came up with that they should enjoy some sort of protection from people stealing their idea. You can't copyright facts or things that are just common. You can copyright a compilation of facts. So, like, for example, I might not could copyright that. I couldn't copyright that someone broke the world record for fastest sprint speed for 100 meters. But if I wrote a book like the Guinness Book of World Records, we could copyright the Guinness Book of World Records, because even though we're not copyrighting the individual facts, what we're copyrighting is the compilation of facts. We're copyrighting the work that it took the author to put all those things together in a certain way, if that makes sense. Yes, ma'am. Yeah. Yeah, so that's it. So I don't. I wish I knew the exact answer to this. I think that because I've read about this before, the Georgia G and the Packers G are the same, basically. I think that I'm pretty sure the Georgia G was first. So when the Packers G came along, I don't know if they got permission or if Georgia never challenged it, or if they just decided that the colors were different enough. But I think that if the Green Bay Packers G had never come along, and let's just say tomorrow all of a sudden it springs up, I can see a trademark lawsuit on that for sure. But I don't know. All of the intellectual property law stuff is a case by case basis. So you're right. You see high school teams taking on logos that look a lot like professional logos, and the reason for that would be first of all, that's a cool logo. We do kind of want to be associated with that. We're not maybe copying it exactly, but we're being a lot like it. And it'd be up to the original trademark owners as to whether they wanted to actually file a suit on that. Maybe the Philadelphia Eagles don't care about the Marion County, Georgia Eagles having their same thing. I mean, but maybe they do. I don't know. You'll see when you start researching this for your assignment on Thursday that there are an awful lot of people who do care and do sue about it. But that's a great question. There's a lot of stuff that probably people let slide just because either it's not worth their time or it doesn't really affect them negatively. Because, I mean, listen. Go ahead, Clark. So, I don't know. That's what I'd love to know, how that happened, because it's the same sport. I mean, they've put it on the exact same thing, which is a helmet. So it's not like there isn't likelihood of confusion necessarily because, I mean, I would argue it's different colors and it's different leagues and all that kind of thing. But at the same time, it is take the color out, it's the exact same thing. So I'm not sure how they came to coexist. That's a good question. If somebody wanted to look that up for Thursday, that'd be a great thing to report on. Yes. Yep. All right, so did you go to Northside? All right, so Northside were the Patriots, and whose trademark were they? Do you remember? Was it New England Patriots or? But somebody came along and said, "Hey, that's our trademark." That's interesting. Anybody else know anything about Northside, the Northside situation? It's still the Patriots. Oh, the N. Oh. So their N could have been just like somebody else's. Interesting. Like you couldn't trademark, I guess the team name Patriots is not trademarkable because it's a regular word. That's interesting. The the restaurateur Mark Jones in Columbus, who owns a lot of the good restaurants. He opened that restaurant downtown, Smoke, but he initially spelled it Smoque. I think that's right. And he got sued for that because that was somebody else's trademark. And he changed the spelling of it. Thomas. Yeah. That they added the bourbon part in there or something like that. Yeah, I mean, you can add, the more you add to it, the more you're differentiating what you've created from the original. And the more defense you would have against a lawsuit for infringement or dilution. But again, infringement means you're just straight up, copying something. Dilution means you're being enough like it to confuse the public. Nikki. Yeah. So if they change logos, it's still protected. Right. That's right. But keep in mind too, we don't want to confuse logos. I mean, trademarks and copyrights, because trademarks have to be registered. So if you're gonna, if you want protection for your trademark, you've got to have it registered and you've got to keep renewing that. Copyright is more for an artistic expression. So we're talking about a business's logo and all that. That's trademark. Copyright is for books, music, sounds, pictures, paintings, things like that. But yeah, the general question is, if you stop using something, does it still gain protection? I would bet that there are cases about that where somebody picked up a logo or picked up something that's defunct, that maybe is not either, the company's out of business or something like that, and got sued for it. And they're like, well, it's not in use anymore. So I guarantee you there are some cases like that kind of stuff. That would be the argument in a lawsuit like that is, well, I'm not stealing it from you. Your business went out of business 70 years ago. There's no likelihood of confusion. But it would go back to whether it's registered or not. There are some exceptions to copyright use. So, for example, I can use in the classroom an excerpt from a textbook, or I could use a slide from the textbook like I've done in this class to put up on the board for y'all. It's called the fair use exception. I could, if I'm doing a movie review and I quote a line from the movie in my review, I've reproduced some of the dialogue from that movie, but I'm doing so in what is known as the fair use exception. I can do that. I can do that as part of a music review, a book review, movie review. I could copy a paragraph of something for use in a lesson or for use in a criticism piece or something like that. That's not copyright infringement. The fair use exception. Excuse me. The factors that you'd look at if you're looking at something like whether or not it was fair use is somebody using it for commercial profit or is it nonprofit? If I'm going to take a line from your song and print it on a T-shirt and sell it, then that's not fair use. That's me straight up taking your copyrighted material and profiting for it myself. But if I'm putting it on the board for an example in a classroom setting, then that's not a commercial use. Trade secrets is kind of the last category that we'll look at. And trade secrets are things that are unique to your business. So think like your recipes at a restaurant, the formula for Coke, the 11 herbs and spices of Kentucky Fried Chicken, the McDonald's special sauce recipe, the search algorithms that Google owns or that Facebook has developed. Those are all trade secrets, and those enjoy protection as well. So things like your customer lists, your business plans, your research and development, your pricing models, maybe some of your marketing research, your techniques, anything that's unique that a business has developed of its own, that's unique to it, those enjoy protection. You can't steal those. You can't sell them illegally. You can't, take those and use them for your own without having compensated the original owner, or without having permission from the original owner. So those are trade secrets. So the areas of the intellectual property that I really want y'all to be familiar with that we've talked about are trademarks, patents, copyrights, trade dress, and trade secrets. And to just summarize, those all enjoy protection under the law from reproduction or use without permission at both the federal and state level. And they enjoy protection from being just straight up stolen and used in an infringement or a counterfeit situation, or in being diluted and being used in a way that's similar enough to the original that gives some association with the original or takes away from the original in some way. So your assignment for Thursday is